All right, hello everyone, and good afternoon and good morning to those of you joining us in other time zones. Thank you for attending this next installment of the Society of American Archivists Records Management Section Hangout series. We're glad that you could join us live or watch us later when it's convenient for you. So today we're going to be taking your questions about the Federal Records Act and the Presidential Records Act, and how federal and presidential records are managed. So my name is Beth Cron, and I am the chair of the Records Management Section. And I am joined today by Era Tanzi, who is the incoming chair of the Records Management Section and will take over after the annual meeting coming up in July. A little plug for if you will be attending SAA's annual meeting in Portland, please join the Records Management Section and the electronic records section for a joint meeting where we'll be having a discussion on managing email. I think we have a really great panel lined up to talk about it from various perspectives, so please join us if you'll be at SAA. So today we are joined by 4 experts on our topic from the National Archives and Records Administration, or NARA. We have Gary M. Stern, who's General Counsel for the National Archives and Records Administration. He also serves as NARA's Chief Freedom of Information Act Officer, Senior Agency Official for Privacy, and Dispute Resolution Specialist. Hannah Bergman, who's off camera and can answer any questions, is NARA's first Chief Privacy Officer and Counsel for Privacy and Information Policy. Then also we have John Laster, who is Director of the Presidential Materials Division within the Office of Legislative Archives, Presidential Libraries, and Museum Services. And then finally, Laurence Brewer, who is Chief Records Officer for the U.S. government. And I would also note that he was featured on the first installment of the Resourceful Records Managers series on the Records Management Section's The Schedule blog, so you could read about that there. So in the announcement for today's event, in the blog post, I shared an article that was in the latest Archival Outlook by David Ferriero, who is Archivist of the United States. So if you haven't read that, I'd really recommend it. That article provides a great overview of the statutes and could provide some good background if you wanted to share that with anyone else. So without further ado, I'm going to have each of you say a few more words about what you do at NARA and your role in implementing the Federal Records Act and the Presidential Records Act. So after we do that, then we'll have plenty of time for questions and answers. So how about we start with you, John?
Hi, as Beth said, I'm John Laster. I am the Director of the Presidential Materials Division here at the National Archives. I work very closely with Gary Stern and others in the agency to provide guidance as requested to the incumbent president on implementation of the Presidential Records Act. Also work with the libraries and the representatives of the former presidents on access issues related to the Presidential Records Act and the Freedom of Information Act.
Okay, I will go next. Gary and I just had a sidebar and we decided this would be the best order. So my name is Laurence Brewer. I'm Chief Records Officer for the U.S. government. I'm not going to give you a lot of details about myself because you can read the blog that Beth referred to in her opening remarks. You might actually even learn a few things about me that you wouldn't guess. So in terms of what I do, I work with the federal agencies, and we work within the context of the Federal Records Act. And we do a number of activities working directly with agencies around records management training, developing policy requirements and guidance. We have an outreach program, so we do a lot of events. I do a lot of public speaking, and sadly I won't be at SAA this year, but I will be at NARA next week, so if you happen to be going to Boise, please stop me and say hello. And then other elements of the program are operational things like records scheduling and appraisal, and then the fourth program that we have is our program that focuses on records management reporting and oversight. So we collect a lot of data. Many of you may have heard of the records management self-assessment. We collect data from senior agency officials for records management. And we have been collecting a lot of data around email management over the last couple of years. And then, of course, we have an inspection program. We do go out to agencies on site and we review and assess practices and their levels of compliance with the requirements and regulations that we have promulgated under the authority of the Federal Records Act. With that, I will turn it over to Gary.
Okay, this is Gary. I'm Gary Stern. I'm hoping we're on your screen. I'm General Counsel, as Beth indicated, for the National Archives. I've been here as General Counsel since 1998, sorry. So it's my 19th year at the National Archives, and I oversee NARA's legal staff of 9 attorneys. But I also have responsibilities overseeing NARA's FOIA program and Privacy Act and privacy program as well. And my bio is actually up on our website. And I guess the one interesting fact that's worth mentioning is before I was at the National Archives, I spent the early part of my career as an attorney at the American Civil Liberties Union, where I actually sued the National Archives and the White House on issues relating to the Presidential Records Act, the Federal Records Act, and the FOIA. It was the original email case called Armstrong versus the Executive Office of the President, and the case that established that the electronic copy of an email is a distinct record from the paper printout, and it's helped guide NARA policy and records management policy ever since. And then subsequent to that case, I applied for and was selected and hired by the former Archivist of the United States to be the NARA General Counsel. So it's been great being here all these years. One of the things we put together is my favorite book, The Basic Laws of the National Archives and Records Administration. But even though we print a very limited number of print versions of this for our internal use, all of our basic laws are on the NARA website at archives.gov. So you can find them there, and I thought I'd just spend a few minutes walking through kind of the background and history of the FRA, the Federal Records Act, and the PRA, the Presidential Records Act, and maybe even start at the very beginning, which is when NARA was founded back in 1934. Is when the government created the National Archives. Before that, there was no National Archives. So the first 150 years or so of our history, there was no centralized place to both manage government records and preserve the permanent government records. That meant every agency kind of did their own thing, somewhat randomly and haphazardly, and the State Department tried to keep the really important stuff like treaties and the Constitution. Presidents and their papers were considered their personal private property. They could do whatever they wanted with them, and they sometimes donated them to the Library of Congress, to their state historical society. Sometimes they passed them on to their family and friends, and so the kind of history and preservation of presidential papers in the 19th century is, again, rather haphazard. President Roosevelt, FDR, signed the National Archives Act of 1934, considered it one of his most important achievements, and then selected an archivist whose first job was to go to all the agencies, figure out what they had, and pull out and bring in what was important, worthy of permanent preservation. And they spent about the first decade doing that. And it wasn't until the late 40s and then ultimately in 1950 that Congress passed the Federal Records Act in various forms. One portion of which is actually technically known as the Records Disposal Act, and which speaks to the notion that for federal agency records, over 95% of federal agency records are considered temporary and ultimately must be thrown away, disposed of. And as Laurence briefly described and can go into in more detail, that's one of the core missions of the National Archives and Laurence's office and staff is to schedule records for disposal. The vast majority of federal agency records are scheduled for disposal. And then the key job is separating out what's temporary and should be disposed of from what's permanent, and then that which comes into the National Archives when it reaches the right age, usually anywhere from 15 to 30 years old. And so that's a huge and crucial undertaking that Laurence oversees to ensure that permanent records are maintained as long as the agency needs them, and then transferred into the National Archives, into the holdings, the archival holdings of the National Archives and Records Administration, both here in the Washington, D.C. area and in our regional archival facilities around the country. So that's kind of the very brief rundown on the Federal Records Act. The Presidential Records Act has its own separate history, and when FDR signed and created the National Archives, shortly thereafter, he came up with the idea that he was going to donate his presidential papers, which were then still considered his personal property, but instead of just donating them to the Library of Congress or maybe to the New York State Historical Society, he wanted to donate them to the National Archives. That was the appropriate place for his presidential papers, as well as the papers of his entire career. And more than that, he said he would build a building for them, which he called the library, Presidential Library, and donate not only the papers, but the library itself, the building with the papers of his presidency and his life career. And create both an archives for the papers and a museum for the public to see and understand his legacy. So he created the first presidential library and the concept of presidential libraries. President Hoover liked the idea so much that I'm going to do that too, and he donated his papers and built us a library, gave us the library. And then President Truman followed suit, as did President Eisenhower. And by then, it became such a normal thing that in 1955, Congress passed the Presidential Libraries Act and created the formal procedures by which presidents could build a library if they wanted to at their own expense, and then donate the library building to the National Archives along with their papers. And that tradition then continued. It was a voluntary tradition, but it continued with every subsequent president. Kennedy and Johnson followed suit, and we have those presidential libraries. Then something happened, a little anomalous, which was what we know as Watergate under President Nixon, and in light of his resignation and President Nixon's original intent, he wanted to donate his papers to the National Archives and came up with an agreement to do so, but he decided that he was not going to donate the tapes, what we know as the Watergate tapes, the tapes of his conversations in the White House. And he intended not to donate those, but actually destroy them after a period of 8 years. That's when Congress stepped in and said, wait a minute, we're concerned about that. And there could be, indeed was, evidence of criminal wrongdoing that the Watergate special prosecutor was looking into. So Congress passed a special law. They seized all the papers and all the tapes and everything of the White House that was up till then considered the personal property of the president. They seized it and treated it as government property and required by law that it all be deposited in the National Archives in the Washington, D.C. area. And so this was in September of 1974, a month after Nixon left office, that this statute was passed, and that all the Nixon presidential materials and tapes came into the National Archives as government property. Nixon actually filed a lawsuit about that went all the way up to the Supreme Court and resolved that was okay, that the statute was constitutional, and the government could take what was considered his personal property. The court said he might be entitled to just compensation. This is under the Takings and Just Compensation Clause of the Constitution, and a separate lawsuit was filed by Nixon to be compensated for the taking. But also in that statute of 1974, Congress set up a special commission to review and study the papers of the president, as well as the Supreme Court justices and the members of Congress. Those papers, those materials of the other two branches, the heads of the other two branches, are to this day still considered their personal property. But this commission made a recommendation that Congress should pass a new law to make presidential records government property going forward. And that's what the Congress did in 1978. They passed the Presidential Records Act of 1978, and which President Carter signed into law, but the law would only go into effect with the next new president. So that's why the PRA only starts and only applies to President Reagan and all subsequent presidents. And so the records that we have since President Reagan are not donated to us at the will and desire of the president, the former president. They are by law automatically government records. They're managed and controlled by the president while he is in office, exclusively. And as John Laster just mentioned, the president can and his staff can and do seek our guidance and advice and our institutional knowledge, but we don't actually have a direct role in managing presidential papers and presidential records the way Laurence does by law in managing and setting the rules for federal records. But when the president leaves office, the moment he leaves office, those records automatically transfer into the legal custody of the National Archives. And one of the big jobs we do that John Laster leads is the transition, when a president leaves office, of all of his records and artifacts and gifts into the National Archives. It's a huge undertaking, and of course most of it now is electronic records that we bring in, and we just completed that in January for the Obama presidential records, and it includes over 250 terabytes of electronic records, over 300 million, or roughly 300 million emails, and about 40 million pages of paper, and a whole lot of other records and files that we now have in our both physical and legal custody. And one final note, though, as we mentioned, for a presidential library, the president, there's a law that allows the president to build and donate it to us, and for us to then run the library as a separate individual place. And every president has done that through President George W. Bush. But as some of you may be aware, and there was a press announcement just a few months ago that President Obama has decided not to build a presidential library archival facility to give to the National Archives. And instead, he's going to essentially pay to digitize that 40 million or so paper records and provide us a digital copy of all those records, so that that we can sort of manage all those and provide access to all the presidential records, Obama presidential records, electronically. He's building a presidential center and museum in Chicago, but that'll be wholly private, privately run, and NARA will not be a part. For the first time since President Roosevelt, we won't be a part of having a physical presence and running a physical presidential library. So anyways, that's the basic background on these two laws. And we know there's lots of interest and lots of questions, and we're happy to take them. Thanks. Now we're going to give it back to Beth.
Okay, yeah, thank you for that thorough introduction. That was our first question, is kind of the background of the PRA and the FRA.
Check.
Check. So I'm going to ask first maybe a question about the Federal Records Act, and that is, how do you perceive the records policy that's created on the federal level influencing the wider records management landscape?
So the good news for everyone out there listening who's not working for a federal agency or in the federal environment, we feel like what we're doing is broadly applicable to other environments. We may do things on a greater scale because we have more customers, more agencies, and there are other things that we do have to deal with, and maybe smaller organizations or private organizations don't have to deal with in terms of like classified records and things along those lines. But as I outlined in terms of what our program in the Office of the Chief Records Officer is responsible for, we start with, you have to tell people what to do and what the requirements are. So we always start with, what are the policies? We have the Federal Records Act. Underneath that, we have regulations and 36 CFR that further interpret the statutes. And we have a number of bulletins, NARA guidance, FAQs, and I shouldn't forget, otherwise Beth will yell at me afterwards, that we have a wonderful blog called Records Express. Beth can probably chat that out. If you Google it, it will come up. So that's really where we start. You got to tell people what to do. What are the requirements? We also have to tell people how to do those things and give them practical guidance. If we really want them to be successful, you can't just say, here are the requirements, and go out and do it. So we do that in the government. I'm sure every other organization is doing the same thing. We work very closely with our agencies to schedule their records, help them identify their records, help them make judgments over what is a record, what isn't a record. And then, in addition to that, and coupled with that, you have to have training. So you work with the customers, you provide the kind of practical support they need, but then you've also got to have a fairly robust training program that takes the policies and the requirements that you issued and puts them in a context that the organization can understand. So we do that through our training program, and we have a fully formed website, learning management system. We have a lot of free content on our YouTube channel where you can go to and find webinars and briefings and other resources that really help tell organizations and customers how they're supposed to meet their obligations. And then the last thing is, you've got to be able to evaluate how well your organizations are doing with complying with those requirements and with the guidance. So we have a program of required reporting and on-site inspections and assessments that we do every year with agencies, where we collect data, we measure the data, we issue reports, and try and gather sort of trends on where the broader environment is. And I think those kinds of conclusions, especially for the wider records management community within and without the federal space, you can find areas where we are emphasizing and putting our resources, which would make sense, I think, for other organizations outside the federal space. So I encourage you to look at our website, look at Records Express, see the kinds of things that we're putting up there that's of interest to us, and I'm fairly confident that it would be applicable within your context as well. Back to you, Beth.
Okay, so as a follow-up on that, for John and Gary, Laurence, you mentioned that you have training and assessments for the Federal Records Act. Are there similar considerations on the Presidential Records Act side?
Maybe I'll start, this is Gary, just by saying that there is not the formal program of records management that Laurence oversees that is established and created in the Federal Records Act as an authority for NARA to perform. There is no equivalent role for NARA in overseeing management of presidential records. The law is very clear and intentional, and it relates to kind of constitutional separation of powers. There were sort of limits on what Congress could actually control with respect to the president directly in performing his job and controlling the people who advise and assist him directly in the White House. And so we don't have that role. But there's also something important to understand, though. One of the key roles that Laurence performs is not only helping agencies figure out what's a record, what's not a record, but even more importantly, what's permanent, what's temporary, separating out the permanent and temporary to make sure we receive permanent records into the National Archives. Under the Presidential Records Act, they don't have to do that because under the PRA, all records are permanent. If it's a record, it is permanent. So they don't have to worry about doing the separation and doing scheduling and all of that. The law establishes that all presidential records are permanent records. So it's much simpler. They just get to keep everything and have to keep everything. There is authority in the law for the White House to dispose of records. And to do so, it's the one place where we do play a formal role. They are required to seek the written views of the archivist before they dispose of those records. And every president has exercised that authority, but only with respect to very administrative type records, like the public mail. We call it bulk mail that comes in every day, like roughly, I don't know, 10,000 letters a day that all presidents receive. From the public, and there's a White House Correspondence Office that responds and manages all of that. But we don't need to keep all those letters and all that correspondence, and so the president's seek, and the archivist has no objection to disposing of those sorts of records. And more recently, with electronic files and electronic systems, the White House has sought and proceeded with disposing of things like the reservation system for the White House bowling alley and the Kennedy Center tickets and all that kind of stuff. Those are records that don't have to be kept permanently at the Presidential Library. So that's a general the kind of background and distinction between the PRA and the FRA.
Okay, thank you. So maybe this might be one for John, kind of asking about how you work with the White House. How do you ensure that the White House is preserving records, and a number of questions about the ability for the president to determine what are personal records, and questions about tweets and all those kind of things, if you want to say a little bit more about that. Sure.
There have been lots of questions about tweets since January 20th. But certainly any records under the Presidential Records Act that are created or received by the White House that relate to constitutional, statutory duties of the president, as well as ceremonial duties, are considered presidential records. So it's actually the definition of what's considered a record is built into the act, as well as what's considered a personal record. So anything that a president is tweeting out relating to his work as the president is certainly considered a presidential record, and that material will be captured and will be turned over to the National Archives at the end of the administration, just like anyone else would, or any other records would. Certainly Gary and I, at the behest of the incumbent president, or the incumbent president's staff, will come in and provide information about how the Presidential Records Act has been interpreted in the past, providing a little context. But as Gary points out, Records Management Authority does reside with the president under the Presidential Records Act.
Okay, thank you. So next I'll kind of turn to one for both of you. Sorry, I can find the question again. So what are some of the biggest differences that you've seen in your careers on how FRA and PRA records are managed? So what are some changes that you've seen over time? Or maybe just since the 2014 amendments would also be interesting, maybe before that and after that.
Well, I can go first,
Laurence?
if you don't mind.
Okay.
So I think in the last couple of years, we're really seeing the traditional paradigms just changing dramatically. So, years ago, we looked at records management from that traditional perspective where we're looking at the content of the records, evaluating that content against a record schedule, and then we were printing and filing it in either a central file, if you go even further back, or in a person's individual files. So in the past couple of years, and a lot of this has to do with the volumes of records we're creating and the impact of technology on how we are managing our records. One of the things that we've been doing here that I'm sure many of you are familiar with is focusing on email as the one piece of information or way for us to communicate that has just become omnipresent. And we got to a point where the traditional ways of controlling, managing, and preserving email just wasn't working in that old paradigm where we were expecting people to print and file it. So we've gone from an approach where it was content-based to one where it's role-based. And I'm sure many of you are familiar with what we are calling our capstone approach to managing email records. And it's become a central part of another driving piece, the Managing Government Records Directive, which we've been working through a number of targets and goals since 2012. But central to all of that is the need to really modernize government and get away from some of those traditional ways where we were managing information. Because really, we've gotten to a point where the old paradigms were more about control, but really now we're focused more on use and access. I mean, that is what people care about. We have so much volume out there. We need to figure out better ways to use technology and tools to be able to access, use, and preserve that information for as long as we need to. Whereas in the past, it was really very, very much focused on control. So, we used to call them records control schedules. We don't really call them that anymore. We still provide disposition authority, but we're doing it in a different way. And I think the records management environment, not only in the federal space, but everywhere, no matter where you work, is being impacted by the technology and the needs of users and our customers, the public, who expect to see information in a certain way up on a website, and no matter where you work, and not go back to the kind of environment where you had to write to an agency and expect to get it out of a central file.
And I would just supplement that, because Laurence just mentioned the capstone approach to managing email. And when we were developing that over the course of really the last decade, the model for the capstone approach is the Presidential Records Act. Because as I mentioned, the PRA, if you think of the president as the top of the government, the capstone of the government, and the capstone in this context is really the top of the triangle. The president is the head of all the government, and by law, all of the records of the president and his immediate staff are considered permanent because they're the most important. And the capstone email approach takes a similar view within an agency, and this role-based approach. If you have the Department of State, it presumes that the senior officials, the secretary and the undersecretaries and the assistant secretaries, the very senior officials, we're just going to treat all their email records as permanent, and then everybody else below them is presumptively temporary. And it was a way to sort of simplify managing email, and also, most importantly, trying to take the user out of having to do the management of email, because every one of us as government employees gets hundreds of emails a day, and just it's virtually impossible to whether print and file or click and file, to separate out the important emails from the transitory emails, from the non-record emails on a daily basis by content. And instead we do it by role, and that allows the systems to automatically preserve and manage our email records without us having to do anything, which is how the White House has been doing it going all the way back to 1994. In fact, as a direct result of that email lawsuit that I helped bring back in my pre-government days. So that's both the intersection and the difference. Another key difference between the PRA and the FRA.
And I'll just add as well that, from a, as Gary and I have said, we have no formal rule in records management, but as new technology has come on board, we're sitting down with the White House and trying to figure out, and this past administration used social media so very heavily. And so it really was a conversation we were having with them of what constitutes a presidential record, all the comments coming in from the public, the things going out, and trying to strike the balance of making sure we capture those things that do relate to the work of the president and the executive office of the president versus all of the comments that are coming in. So that's certainly area where it's new both for the White House, or was new for the White House and for the National Archives, and we would work to, try to figure those areas out.
Yeah, just to add one more thing, it's sort of, because you heard it from both the PRA side and from the FRA side, really the common theme is technology and the impact that it's having. And for the RIM professionals who are out there, whether you're in government or not, we all need to get smarter about what the technologies are, what the impacts are, because we're not going to be able to get ahead of all of these emerging technologies that are out there and being used and may not necessarily be managed. So from social media to encrypted communication apps to the way websites are now being used compared to as little as 5 years ago. These are all things, as a RIM professional, if you're still living in that traditional paradigm, then you're going to have a huge gap and huge risks within your organization if you don't really understand what those issues, challenges are, and then be able to address them through policy, through guidance, and then with effective oversight within your organization so that you correct those gaps.
Okay, thank you. Era, did you have any questions from Twitter? I don't see anything on YouTube. You can ask questions there.
Yeah, Alex Toner had a question, which was, has a sitting president ever requested a NARA briefing on the Presidential Records Act or the Federal Records Act?
So this is Gary, and the short answer is neither John nor I have had the opportunity to do a formal sit down and briefing on the PRA with the president himself, but we do that with the counsel to the president and the attorney staff in the office of the president. They are the ones who are essentially been delegated the authority to oversee records management under the PRA. And so we work with White House counsel on a regular basis on this issue, and to the extent that we've had opportunities to meet with former presidents while in office, it's been in a more ceremonial occasions as opposed to formal.
Okay, go ahead, Era. You got another one?
Oh, no, I wasn't. I don't see anything else coming up on Twitter just yet, but I'll keep monitoring it.
Okay, and then I had a few other ones on the Presidential Records Act. Are there codified punitive measures that can be taken against an administration that does not comply with the Presidential or Federal Records Act? So I guess that's for agencies as well. So the question is there any real bite to the bark?
That's a great question. And in fact, and Laurence alluded to, back in 2014, about 2.5 years ago, Congress passed a statute amending the FRA and the PRA in a number of ways, largely to modernize the statutes in this 21st century with electronic records. And so made a large number of revisions and updating of both statutes. But in that amendment, they actually added provisions in both the PRA and the FRA and the title of the section, I'm opening my statute and I'll read it to you just very quickly. It relates to disclosure requirement for official business conducted using non-official electronic messaging accounts. And this statute since 2014 now requires that if you're a government official and you use a non-official email account or other electronic message account to conduct government business, you're allowed to do so, but you must, by law, transfer, copy, or forward those messages into your official government account within 20 days. It's known as the 20-day rule. And so that's a new legal standard as of 2014. But in that provision, there's a section called adverse actions, and it states the intentional violation of subsection A, the requirement to forward within 20 days, shall be a basis for disciplinary action in accordance with other federal laws. So basically, if you fail to do so within 20 working days, you can be disciplined internally, within your agency for failure to do so. And that adverse action section is in both the PRA and the FRA. And so there is that requirement. Also in the FRA, there is enforcement requirements and authorities in situations where there is the unauthorized disposal or removal of records. And we, Lawrence's office works regularly and closely with agencies when we have cases of potential unauthorized disposal or removal. And the most important thing is to get the records back and recovered. But there is authority in there to either consult with the Attorney General, or the agencies themselves can internally determine if there are adverse consequences for the persons who may have done something, intentional with respect to destruction of records. And there is also a separate criminal provision on the intentional destruction of government records.
Okay, thank you. So we did get a question in from YouTube from Jesse Wilkins. He said, has NARA or anyone else promulgated any guidance around the so-called disappearing message tools, such as Snapchat, and then also encrypted tools as well? So that could probably include Signal or other tools like that for messaging.
Yes, we issued, or actually the Archivist of the United States issued a formal memo to all senior agency officials for records management. I believe it was in March of this year, that focused in on encrypted messaging apps, information up on websites, and Twitter, use of social media, as areas with the new administration coming in, to be aware of the fact that if you are conducting business using any of these emerging technologies, then they are presumably records and they need to be managed. So we identified in that memo to those senior agency officials some of the issues and some of the challenges they would have to work through within their agency. We have issued broader guidance, which is up on our website. We've issued some bulletins related to social media records, and we have issued a white paper on electronic messages, which is also up on our website, which addresses a lot of the issues and the challenges. But in terms of what we have directed agencies to do, the memo that we issued in March is the most recent place where you can go see our position on the use of those particular technologies.
And just to supplement, the core lesson of that, as well as the statute I was just referencing on using non-official accounts, which is that we all recognize that records can be created and received essentially anywhere in any format. And our core message is, if it's a government record, if it's a federal record or presidential record, the agency and the White House is responsible for properly managing and preserving those records for as long as they need to be, regardless of the format. And so we're not saying it's absolutely prohibited to use any of these technologies and these tools, but if you do use them, you must manage them properly and effectively. And we recognize that with some of these technologies, it's more difficult to do so. And so that's what the point of the guidance that Laurence just mentioned was, to remind agencies that they got to figure this out. And I mean, potentially one solution is to say, don't use you just simply prohibit the use of certain technologies if there's no good way of managing them. But there's still the fallback. If someone does it anyway, then they got to figure out a way to copy or forward it in to a government system to be properly managed in 20 working days.
So there was a follow-up comment to that from Jesse Wilkins that he hates to say it, but what he's hearing is that it seems to be not really with regards to punishment for willfully violating the PRA, the FRA. Said, I'd love to hear a specific case where an employee or agency was disciplined.
So we do get that question a lot, and we unfortunately have to answer that we don't carry guns and badges, and there's no jail in the basement of this building, at least not to my knowledge.
So we are not the records police.
Right. So, I mean, our authority is one more of oversight than it is of enforcement. However, we are very big into public shaming. We do publish reports and data. We do report to Congress. We report to the Office of Management and Budget. And in particular, there are a number of high-profile cases which are connected with the process for reporting allegations of unauthorized removal or destruction, where they get a lot of attention, and we do a lot of follow-up and in a lot of cases, on-site inspections to follow up on what corrective actions have been put into place. So we do work very closely with agencies. A lot of it is not out in the public eye, but we do follow up on all of these concerns, and anything that is reported in the news or comes to our attention as a risk or violation of the Federal Records Act, we do pursue it actively and aggressively.
Okay, thank you. Another question from YouTube. As Capstone is based on the FRA and the White House, and similarly high-level government officials who would likely be covered by Capstone retention are more focused on policy versus casework. So I think I missed the question in there.
Well,
so I don't know if you have any comments on that.
It sounds like what the question may be suggesting is, we're considering the policy records to be permanent, and casework records may not be permanent if they're, because they're not high-level senior Capstone officials generally aren't doing sort of the more basic case-type work. And one answer is that probably is the case, that most just sort of basic case-type files, most of those already are treated as temporary and scheduled as temporary and wouldn't be permanent. But there are cases, for example, in the Department of Justice, litigation files, major case files, some of those indeed are permanent, and their schedules have established how to separate those out. They're generally the ones that go to trial or establish new legal precedents or whatever are considered permanent case files. And so those types of records are scheduled separately. Remember, Capstone is only for email records, and it's not the approach we generally use for other types of, and vast amounts of what the government does in conducting its business. There are still more traditional type schedules that we use for managing those records.
The other thing to mention about Capstone is there's often this misconception that as we're scheduling email records within agencies, that we're only scheduling the most senior accounts as permanently valuable within agencies, and it's just not accurate. There may be other accounts at lower levels within the agency where historically valuable email records are being created, and those would be captured as quote-unquote Capstone as well. And the inverse is true. Even at the highest levels of an agency, there may be accounts or roles that we wouldn't deem to be permanently valuable. So for the most part, it is true that the most senior officials in an agency would be scheduled as permanent or captured as permanent and preserved. But it is important to recognize that there are other accounts, roles being performed within an agency at lower levels, which presumably are historically valuable as well.
Okay, thank you. Yes, I think that covered it. Just commenting on that, on capstone versus focusing on the policy. Okay, Era, do we have any other questions from Twitter?
I don't think so. Let me refresh the hashtag right now. Not that I can see.
Okay, and I don't see any other ones on YouTube, so I'm just going to ask one more question, and then we'll wrap it up for today. So how about what's the most interesting federal or presidential records management story that you could share?
You want me to go first? So I was thinking of one as I was looking at John. Right above his head, there's a picture of Ms. Clinton, the former Secretary of State. So I don't know if interesting is the right adjective I would use to describe that case. But as I mentioned, we do keep case files and require agencies to do investigations if there's any allegations of unauthorized removal or destruction. And that case, notwithstanding the high profile and everybody knows about the case, was actually quite interesting for a couple of reasons. One is that looking at the statute where it describes unauthorized removal of records, I mean, technically there was no removal because the records were never within the custody of the Department of State. They were in a basement in, how do you pronounce it? Chappaqua? Chappaqua. So, in terms of what we needed to do as an oversight agency, we follow up on the case because, clearly, there are records that should be in the custody of the Department of State. But, looking at the letter of the law, it was interesting. It almost seemed like, that's something that, the law didn't foresee that happening.
Well, and just to follow up, that on the Hillary Clinton's use of a private email account to conduct her government business, clearly that got huge attention in the public, in the media, by the State Department, in the presidential campaign. Some people say, well, has anyone ever suffered consequences of improperly managing their records? Well, it seems like Secretary Clinton may have lost an election in part for improperly managing her email records. Not only did we open a case file on this issue of improper either removal or disposal, but there's been several lawsuits that were filed against both the Department of State and the National Archives under the Federal Records Act that are actually still being litigated and going to the question of have all the records been recovered that could be recovered, and should the National Archives and Department of State formally consult the Attorney General, even though, of course, the Department of Justice and the FBI did a full-scale criminal investigation into this issue and did recover additional records. But what's also interesting as a legal matter, not only that parsing that question, was there a removal if the records never were in the State Department to begin with, but it also goes to this issue that we mentioned earlier, which is was it improper to use a personal email account in the first place? And the answer to that to this day is it is not improper to use your personal email. Now, since 2014, if you do use a personal email to conduct government business, you've got to transfer it in within 20 working days. Prior to 2014, when Hillary Clinton was Secretary of State, there was no time limit on when you must transfer your records in. So as a formal technical matter, the law did not explicitly say when you had to provide transfer your records back in. And so I think her position was, well, I gave them back when they asked for them. And so in our view, what occurred clearly violated all the norms and expectations of the National Archives and any concept of good records management. It's not clear that at the time it formally and technically violated the law. Now it would if she or any secretary or head of an agency used personal email or personal texting and did not transfer the records in within the appropriate time period, 20 working days.
Yeah, I mean, for me, interesting. There are just so many threads to this particular case and so many consequences, changes to laws, changes in policies, changes to procedures. And another part of that story, which I think has become more important in recent years, is that right now we have this position of a senior agency official for records management. Had there been a senior agency official for records management back then who could have briefed the former secretary, would this have happened? And that's what we're hoping going forward, that now we have this position, we can prevent similar future occurrences because there's someone who can connect the records management program within any organization to whoever is at the top of the organization to make sure that at all levels the right things are being done by records management. So a lot of lessons learned.
Okay, thank you. I know we are reaching the end of our time here. I just wanted to ask John if you had an interesting story that you wanted to share.
Well, presidential records management obviously is a little different since it's managed by the president. But one of the things that I found interesting is that organizations become presidential record act, creating entities often in response to lawsuits. So while I've been at the National Archives, one of the outcomes of the Armstrong case that Gary helped start is that at that point, National Security Council records were both federal, part of them were federal, and part of them were presidential. Now they're all presidential. A case during the George W. Bush administration, the courts ruled that the Office of Administration, those records are also presidential records. So it's interesting from that point of view that there are these small entities, or large sometimes, like Office of Management and Budget within the EOP, that are not governed by the PRA. But slowly, as a response to lawsuits, other offices are being added in, and so it's kind of broadening what was originally considered that we would take in as presidential records.
Okay, thank you. So I'm sure there are a number of questions out there, but I want to thank you all so much for coming today and being willing to be on camera and to answer all of these questions. So thank you once again, and hope to see you all again at our next Hangout. Thank you.
Thank you.